Welcome. Hello, everybody out in YouTube or wherever you're watching this land. Want to welcome you to a timely talk I'm going to be leading with my father, Michael Gilfix, on protecting family assets. How can you take your plan to the next level? We want to offer you the tips that the top 0.1% kind of already know. We want to offer them for you. We're going to go through a few key concepts. Michael Gilfix is my father, a legend in the field of estate planning. For those of you who don't know our firm, we are Gilfix and Paul, national leaders for over 40 years in the community. We serve people throughout the state of California. Whether you are in San Diego or Wairika, throughout the state, we can work with you. So we're very proud of our heritage, and our mission is to provide education and knowledge and return on investment and value when you work with us. And I think most importantly, peace of mind. We want to empower you and build that plan for you and for your family. Protecting family assets, this is sort of a masterclass in next level planning. So we're going to briefly talk about the basics of what you need to have in place, but really this is about making sure you have the right core plan in place, a revocable living trust, power of attorney, advance directive, but the tools you can build on top of that to protect assets for multiple generations, to protect your home or rental properties in California from insanely large property tax increases, and to understand how to bring it all together and how to build that team. We think everybody should have that team. It shouldn't be reserved for only the 1/10 of the 1%. Let's briefly revisit the three documents that everyone needs. If you're over 18 and you're watching this, if you have any assets, you need these three documents: a revocable living trust, a durable power of attorney for finances, and an advanced healthcare directive. A living trust, much better version of a will. There's so much more we can do with it. It ensures your assets are not stuck in the courts after you're gone. A will means your assets can be stuck in the courts for 2 or 3 years, something called probate. It's so expensive, it's public, terrible. You need a trust. Durable power of attorney for finances, who can step in and manage your day-to-day finances if you're incapacitated and can't manage for yourself. Advanced healthcare directive, what if you're in the hospital and can't speak for yourself? Who can communicate for you and what would you want? You need these three documents into place. The rest of this is about building on that, making sure you have the right trust structure if you're married, and the other tools we would add to this. But you need to have these in place. And of course, we can help you as we help thousands of California families to put their estate plans into place. Larry and Susan have a $3 million estate. Susan outlives Larry by 5 years. Let's face it, women often live longer than us guys, right, Dad? That's what we see, and that's what the statistics say.
That's what happens.
That's what happens, right? When they pass away, their children face $300,000 in capital gains tax exposure. Wyatt and Jane, same thing, $3 million estate. Jane outlives Wyatt by 5 years. Their estate grows to $5 million, good-sized estate. When they pass away, their children have zero capital gains tax exposure. What's the difference? What's the mystery? Let's explore that. One other example, though, just to make a point. A larger estate. Ben and Ann have an estate worth $10 million. By the time the second spouse passes away, it's grown to $18 million. They've crushed it. But when they pass away, their children owe over $1 million, or their estate owes $1 million in estate taxes. Jacob and Sarah, same exact situation, $10 million estate, grows to $18 million by the time they pass away. But when they pass away, zero estate tax exposure, a $1 million difference just based on having a different living trust structure. Mike, why don't you walk us through this? And let's start with 2AB or not 2AB. That is the question. That is a very lame take on a Shakespeare quote. You know, we're lawyers. We have to be as funny as we can.
So the first thing to say is that this AB trust structure is for a married couple. If you're a single individual, this doesn't apply. It's still interesting to you because of the benefits of a trust, but you still need a trust. Let's be clear. If you're a single person, you still need to do a trust, but this AB trust issue is not yours. Now, if you're a married couple, if you did your trust 3, 4, 5 years ago or earlier, you would have had an AB trust. We would have done that for you. Virtually every other attorney who understands this world of tax and planning would have done the same thing. Now, why? The bottom line reason for this AB trust is to make sure that we capture for each spouse the maximum level of estate tax protection. It wasn't that long ago when the level of estate tax protection for an individual was $1 million. I guess you only $1 million. A little before that, it was only $600,000. So it's kind of a moving target, and we always want to make sure that we maximize protection from this 40% tax. With the AB trust, here's what happens. At the time of the first death, the estate is going to divide into 2 subtrusts. And importantly, you'll see on the screen, everything in the estate gets something called the stepped-up basis at the time of the first death. All community property assets. Okay. So that means that if you paid $10 for a share of stock, that's the cost basis. If you sell it for more, for $20, you have a $10 profit or capital gain, and you have to pay capital gains tax on that. If you buy real property, the price you pay is the basis. So at the first death, with my example about stock, the basis will increase to reflect the market value. The basis goes up to $20 a share. The survivor could then sell that stock for 20, subtract the basis of 20, no gain, no tax. Okay. And it underscores, also as an aside, the need to make sure that the work is done properly after the first death. You have to document the stepped up basis very carefully so that the IRS can be satisfied if there's ever a sale and then a question raised. At the time of the first death, we're going to pick on the husband as the first to pass, as we've alluded to. Us guys usually go first. It's just math. It's the way it is. Okay, husband dies first. His half of this trust is going to go into the exemption trust, which is generically called the B trust. And by the way, AB. B is below ground, the person who is deceased. A, the survivor's trust, is above ground. Okay, so we're talking about the B trust. So when that $3 million goes into that trust, currently, the level of estate tax protection is much more than that. So everything that goes into that trust is going to permanently capture protection from estate tax. It's removed from the survivor's estate. It's all going to be there for the next generation. That the money in that trust could grow to any amount of money. It could grow to 20 million. It will pass intact because protection was captured at the time of the first death. Okay, the other half of the trust estate goes into the survivor's trust, the A trust. That is in the estate of the survivor. Assets in that trust plus any retirement money that might remain, those would be added up at the time of the second death to see if there's any exposure to estate tax. At the second death, assets in the survivor's trust get another stepped up basis because the assets are in the survivor's estate. So the exemption trust, that trust, those assets are not in the estate of the survivor, so there's no second stepped up basis, which could be incredibly important if assets have grown dramatically in value, or maybe it's not so important depending on what happens. We have a very different treatment of capital gains and stepped up basis when you utilize the AB trust. So the benefit, assets in the exemption trust can grow without limit, never exposed to tax. Kind of the downside is they don't get another stepped up basis. Now, because of a change in law about 5 or 6 years ago, we have a new opportunity. We have something called portability. And what that means is that we can simplify the trust so that the trust does not divide into two subtrusts. Instead, it remains intact under the complete control of the survivor, but we can still capture the maximum level of estate tax for each spouse. So at the time of the first death, we're still protecting $3 million. So we're not giving up the maximization of estate tax protection for each spouse. We're simplifying the trust. A benefit of this approach is that we get a stepped up basis at the first death and we get a second stepped up basis for all assets at the second death. So let me give you an historic note here about how folks usually treat this. We have counseled way over 100 folks who came in who did the AB trust previously. Our data is that about 2/3 of our client couples, they change. They go from the AB trust, they go to this continuing couples approach for a combination of reasons, mostly simplicity and knowing they're not going to give up any estate tax protection. About 1/3 keep this trust. It's not black and white. It isn't only one way, only the other. It's a matter of looking at a number of criteria, a number of factors in your life to see which trust structure makes the most sense.
I think really the focus is often for families who don't have very large estate, which even in California and Silicon Valley is the majority, capital gains taxes are the big issue. We want to avoid capital gains taxes because we can protect so much from estate taxes. So that, as Mike said, 2/3 of our clients who come in the last couple of years who previously had an AB trust have switched. Now let's just go back to the mysteries. Let's talk about Susan and Larry versus Wyatt and Jane. Susan and Larry had the $3 million estate, grew to $5 million by the time the second spouse passed away. Their kids had $300,000 in capital gains taxes. Wyatt and Jane, same situation, 0 capital gains taxes. Why? Larry and Susan had an AB trust. So as we talked about, half their estate did not benefit from the second step up in cost basis when the second spouse went away, leaving their kids with about $300,000 in taxes in capital, leaving their kids with about $300,000 in capital gains tax exposure. Wyatt and Jane had an AB trust, but they simplified it so that they could get that second step up in cost basis, 0 capital gains taxes when they passed away. It was all wiped away. So again, don't need to follow the details other than simplifying the trust structure can have massive implications for capital gains tax exposure if you don't have a very large estate. There's other issues we look at. Now let's look on the other side of this. We talked about Ben and Ann with a $10 million estate. They grew to $18 million. Their family faced $1 million in estate tax exposure. Jacob and Sarah, their family had zero estate tax exposure, even though they had the exact same situation. Why? Well, Ben and Ann didn't use the AB. They had the simplified trust, the simpler structure, but they should have had the AB because they faced estate tax exposure and they didn't freeze growth out of their estate. So they had too much in their estate when the second spouse passed away and they had $1 million in exposure. But Jacob and Sarah had an AB, and for them, it was right. And it saved their family $1 million in estate tax exposure. So I think the point here, again, there's no one size fits all solution. There's other factors besides taxes. But if you are married, and from a tax standpoint, there's other issues too, but if your estate is under $5 million, you almost certainly should simplify and not have an AB trust. You should have that simpler trust structure. If your estate is over $9 or $10 million as a married couple, you almost certainly should have an AB trust structure. Again, there's other factors involved. If you're in between that, it's kind of a gray area, and we talk to people about that.
Our job is to explain these things in individual meetings and make sure it's understood. A number of factors. We go through the criteria. Let's figure out what's right for you. Again, multi-generationally, that's what we're talking about here. And we'll come up with a recommendation in 9 out of 10 cases.
Let's talk about the secret trust of the 1% that protects your assets for multiple generations. What would you say is the key to protecting assets for your kids and grandkids and great-grandkids?
Well, I think the starting point, by the way, is don't leave a penny to your kids.
Wait, what?
Leave nothing to your kids.
What did you just say?
Our advice, don't leave a penny to your kids. What the heck? What is that all about?
What is it all about? So don't leave. So obviously you can protect assets if you don't leave anything to your kids because there's nothing to protect them from. But let's say you want to protect them, but you do want to have something there for your kids. What do you mean there?
Well, clearly the answer, this is one of the magical answers that we talk about to make sure that life is good, life is better. Let's reach the heights. Let's go to the mountaintop. Let's come up with planning that just lets you soar. And that's what this approach is all about. And this is the use of what is generically called a dynasty trust.
And do you like Bridgerton? You might be picturing families like those featured in Bridgerton when you think of dynasty trust. Like, I'm not like them. I don't have teams of servants. I'm not friends with the queen, although we don't really have queen here in the U.S. But I hate that term also. We talked about, we don't like the term estate planning because what do you think of when you think of estate? Similar with dynasty, you might think of dynastic wealth like the DuPont family or the Walton family from the Walmart fame and a number of other super wealthy American families. But the reality is there is no reason why only billionaire families should be able to use these tools. We think everybody should be able to use these tools or at least understand them. And if you own a home, we think that's enough in the way of assets to justify creating these trusts. So what are we talking about here? Well, our version of these is a family protection trust. And Mike has published an article in Bottom Line Personal Magazine very recently. But as my dad said, to my chagrin, if you want to protect assets, you don't want to leave a penny to your kids. So imagine you have, well, in our family, 3 kids. Not a penny would go to me or my sisters either way, like none of us. Instead, there would be 3 trusts, 1 family protection trust for each of us. You leave money to Mark's family protection trust, to Shauna's, and to Jamie's. Why would you do this? Well, there's 3 big reasons. Again, it doesn't have to be a huge amount of money to justify this. 1, we know divorce rates are so high. They're between 40 and 50%. This is what the data says. If your child divorces, if they've inherited assets, if they've commingled at all, a big chunk could be lost to the ex-spouse, and they might have another family, might go to people you don't even know. If it's in a family protection trust, it's kept kind of separate and protected in a divorce settlement. So in some ways, it's like a prenuptial agreement for inherited assets. 2, if your child is sued, assets they inherit directly, well, that's fair game. There's no protection for that other than hopefully a good lawyer. If it's in a family protection trust, you've created a barrier. It makes it a lot harder for creditors and people suing your child to get access to that money. Nothing's 100%, but it creates a barrier. And that's often the name of the game. And this is something that's extraordinarily powerful. When your kids and your grandkids pass away, the assets that you leave them directly, it's all part of their taxable estate. So whatever they earn plus whatever you left them plus growth is all exposed to estate taxes when they pass away. And right now you can pass a lot to your kids and to anybody. It's $12.92 million a person, but the exemption's set to drop in coming years. And who knows what estate tax laws will be like in 20, 30, 40 years. So the fact that we can protect against this by leaving it to a family protection trust is huge. The assets in the trust, there are some limits to this, but largely speaking, the majority of assets in family protection trusts plus growth are not part of your child's taxable estate. They can go largely untouched for the benefit of your grandkids. If you're okay with it, your child can be his or her own trustee. They don't have to be. If you don't think they're good with money, you can name someone else to oversee it, but they can be in charge of their own trust. So you're not necessarily tying their hands, you're just giving them this really protective tool that you've set up basically once, and it provides about 100 years of protection. So they last in California for about 100 years. So through the lives of your children, your grandchildren, even part of the lives of your great-grandchildren. And this should not just be for the ultra wealthy. So talk to us if you want to do a family protection trust for your kids or one for each child. Such a powerful tool. This is how you can take your plan, as Mike talked about, from the base of the valley to the mountaintops. And it doesn't take that much complexity or work.
This trust should be set up. There's no downside.
Right. It should be a separate trust, by the way. Once in a while, we see people coming in with it's embedded in their trust that is to become some form of a dynasty trust. For many reasons we're not going to necessarily explore here, they should be separate documents. You have your living trust, separate family protection trust, one for each child. Many reasons for that. Just trust us here. You got to trust us to some extent. That's how we do things for many good reasons. Prop 19, property taxes in California, what you need to know. Some of our videos have gotten the most traction, have been around Prop 19. Mike, why don't you lead us through really quickly what Prop 19 is and how it changed California law and how it relates to Prop 13, why many are calling this the end of Prop 13 for families in California.
First thing to say is that Prop 19 is a change in law, but more accurately, it's a change in the California Constitution. And the reason that's so important is it means that the California legislature can't fix it. They can't change it. It's going to take another voter initiative to again change the California Constitution to get rid of or to modify the terms of Prop 19. Now, what does it do? In the minds of many, it guts Prop 13, the hallowed Prop 13 that became law by a voter initiative back in the 1970s. And of course, that rolled property taxes back to a very low level, 2% modest increases every year. Millions of Californians are now paying $5,000 or $10,000 in property taxes, while their next door neighbors might be paying quadruple that or even more because they purchased property more recently. So we have Prop 13 that rolled taxes back. The next thing that was so significant was another voter initiative, Prop 58. And Prop 58 did two things. First, it said that your residence can be passed along to your kids with no property tax increase. Doesn't matter if your kids live in the house, doesn't matter what the value is, the residence goes to the kids, no tax increase. It also said that another $1 million in assessed value, a rental, a vacation home, that can also be passed along to your kids without an increase in property taxes. And there are many $1, $2, $3 million vacation homes, for example, that have assessed values of like $200,000 or $300,000 or $400,000. So properties were being passed along routinely without property tax increases. So Prop 19 guts all of that. So here's what it does. It has two treatments. There's one treatment for the residents where there's a bit of protection. There's been confusion about this. The San Jose Mercury published not one but two articles saying that if you have a kid and your kid lives in your home, there's no property tax increase. And that's not accurate. What is accurate is that if it's your residence and one of your kids makes the house her residence, then the first $1 million in reassessment is forgiven. It's partial protection for most properties here in the Bay Area. Now, in some parts of the state, many parts of the state, condominiums, the value is much less. So if a house is worth $1 million or $1.2 million, this protection will eliminate tax for the residents. But again, in our community, property values are just so large that that's not going to be complete protection. Now, we have a different treatment for property other than the resident. A vacation home, a rental, the duplex, whatever it is, zero protection from from property tax increases. So you have to be aware, you have to realize that this is on the horizon upon your passing, but it can be avoided.
Yeah, and I actually you made a really important point though. A lot of people in our community in the Silicon Valley and some of our clients in San Diego and West LA, the fact that Prop 19 only protects $1 million, again, you can take the assessed value at $1 million, and if your kids live there, that whole portion of the value of your home is protected from reassessment. In high-priced areas, that doesn't do much necessarily. Taxes still skyrocket, but a lot of California, that could be enough to protect the house. So I think it's very important for those of us in very high-priced housing communities to realize that what's true in these communities might not be so true in other parts of California or for people who own condos, that the Prop 19 protection may be enough. So if your child lives in the house, they can keep the same property taxes as you. So I think that's important. We're thinking about, what might happen with this law. does it actually affect as many people in California as you might think? And it might be a lower percentage than you might think. It's not just about keeping low property taxes for the home if your kids live there or not, because we can take steps to protect those low taxes. You can talk to us. We have tools for it. But the home is more than that.
For 40, 50 years, really thought deeply about what a house is. What's their residence mean? So many folks think of it as its value. Oh, it's worth so much. I've made so much money on it. I really don't think that way. The home is the hearth. I mean, it's a little old-fashioned, but it's really true. It's the core of the family. For us, home births. My God, our kids were born at home.
That's true.
There's a real legacy.
Yeah, me and my two sisters all were born in the house that we grew up in. So the house is a lot more than just a place to live. It was literally where we were born.
Yeah, and that's why in many areas of our tax and public benefits law, the house is treated differently. There's some degree of protection if you sell your home from capital gains tax. In the context of eligibility for Medi-Cal, the home is exempt, the value doesn't count. So it's consistent with our culture and our values to treat the house differently. And yet, again, Prop 19 significantly erodes that, to the chagrin and shock of so many Californians. It's something to think through very, very deeply.
Francis LaPole, our tax guru, has developed some incredible solutions for families who plan ahead. And some of our videos and educational videos about Prop 19 have gotten a lot of traction. We've been seen by literally tens of thousands of Californians. So we get calls about this pretty regularly. We've helped many families to understand and plan for this, but we've also gotten calls that came too late. We've gotten calls from a few people who inherited a house from their parents 9 months before. They get these massive tax reassessment bills, these additional tax bills, and they call us saying, whoa, what happened here? I moved into my parents' house, and I just got a $25,000 property tax bill. Can you help me? And the sad thing is, in most cases, there's very little that we can do. Once taxes go up, they stay up. Right? So we have to plan ahead if this is a concern. And I think it's important to understand, though, the forces at work and the different arguments, because certainly many in our client community think Prop 19 is horrible. They worked hard to build up assets, to own properties, and they're really upset that their kids might not be able to hold on to these properties. And we totally get that. They feel like the rug was pulled out from under them. But Prop 19 was passed by voters. So a lot of people, I think, rightfully say, well, voters didn't really understand Prop 19. That's why it passed. So if there's a chance to repeal it, it'll get repealed. We need to understand the forces at work and the arguments on both sides. And so I have friends around my age, some of whom are from California, where they hope to inherit mom and dad's house or a rental property, and they would love to keep low property taxes. They think Prop 19 is grossly unfair. It's their only chance to stay in the state of California because they can't afford much higher property taxes. But I have friends who moved to California from other places. They're not going to inherit anything. And they think Prop 19 is totally fair. They say, well, why should my friend who just inherited a rental property pay much lower property taxes than me if I work hard and buy a new rental property? And that's where attacks on Prop 13 are coming from as well. So those same attacks apply here, where people say, why should wealthy people who inherit properties get low property taxes versus someone who buys it more recently? And we understand that argument. It's whatever your point of view, leave us a comment. Let us know what you think. Do you think Prop 19 is fair? Or do you think it's not fair? If it does go up for a vote for repeal, I would bet that the Realtors Association, which really put a lot of money into passing this in the first place, would probably continue to fight for that. Public employees unions would probably fight to keep it law because it's going to lead to billions of dollars in extra revenue for the state of California. Whether you think that's good or not, it's going to be a lot of money over time for the state. So planning for Prop 19 and keeping taxes low. If you have properties, don't wait on California voters to bail you out on something making the ballot and getting passed. Don't wait on Congress to bail you out. That is almost the definition of insanity, waiting for third parties to bail you out. Let's control what we can control. And we do have tools available. Francis LaPole, our tax guru, has developed several strategies, and there's no one-size-fits-all solution. But he's developed several strategies we've used for many, many families to protect a rental for the next generation, or to protect the home for the next generation, keeping property taxes low while getting optimal tax treatment in other areas. We're especially sensitive to this if you have a child with special needs. And we have a lot of clients who they want to buy a duplex, or maybe they have one. They bought it literally with the idea of my child with special needs can live in one unit, they can rent out the other to support their needs. If property taxes spike after they're gone, maybe that no longer will work. There might not be enough to support their child with special needs. So if you have a child on the autism spectrum or with a disability, this is especially crucial. The stakes couldn't be higher. Rental properties, we talked about the home. You can protect $1 million in assessed value from a reassessment. Sorry, $1 million in fair market value beyond the assessed value can be protected from a reassessment if your child lives there. Rental properties, there are zero protections unless we plan ahead, full reassessment. For a $2 million property with a $200,000 assessed value, the difference over 20 years can be $480,000 in property taxes, over 30 years, almost over $800,000 in property taxes. If you have a child with special needs, that is $800,000 over their lifetime that is going to the state government rather than to support your child if you don't plan ahead, if you have a low assessed value property. So imagine a future where you plan ahead and we can hold on to the family home for multiple generations or rentals for multiple generations. And we have developed solutions. You can see our other videos. We have the Gilfix and the Pole Dynasty LLC. It's a different solution for every different family, but we have ways where we can keep property taxes low for future generations, and we can do it while keeping in mind capital gains tax issues, estate tax issues. You want to get that stepped up basis, ideally, when you pass away. So capital gains taxes are wiped away, but there are ways that we can protect properties for multiple generations if we plan ahead. I want to talk about estate taxes and the coming cliff. So right now, we are at a historical period with the highest estate tax exemption in history, except for 1 year, there was no estate tax. It's the year George Steinbrenner died. I don't know if you've ever seen that. So George Steinbrenner picked a good year to pass away. His family faced zero estate tax exposures, even though they inherited the Yankees. There was 1 year where Congress just didn't get its act together. I think it was 2009. I can't remember exactly which year. There was no estate tax. But other than that year where there was no estate tax, this is the highest exemption we've ever had. What is the current exemption? How much can you pass tax-free? It's $12.92 million per person. So you can pass $12.92 million per person between a couple. It's almost $26 million under current law that you can pass to your kids without any estate or gift taxes. That's a lot of money. And you might be thinking, well, Mark, I don't know how to worry about that unless I sell a company. And we do have some clients, in the wealthier parts of California, there are a significant number of families who face this issue even today. And you have to plan ahead. There's so much you need to do right now. We can help you. Okay, in 2026, unless Congress takes action before then, we have a cliff coming. What do I mean by that? The exemption is set to drop by 50%. So it's likely to drop to around $6.5, $7 million per person. That's still a big number, right? You have to have, if you're a couple, that's 14 million that'll be protected. But if you're single, that's about $6.5, $7 million that'll be protected. Again, your estate includes everything you have now plus future growth. So if you own a house in a nice area, the house alone could get you to estate tax exposure. And if you're earning money and your estate is growing, you need to make sure that you're aware of this, because a lot of people are going to be caught sleeping. And I guarantee you, right before this deadline comes, offices like ours and any estate planning or tax planning expert, we're going to be overrun with people frantically saying, oh God, I didn't realize this was happening. Help me. And we will not be able to help you. If you're a new client, you haven't contacted us with enough time to spare. So be aware of this. You are ahead of the game. You're watching this video. Let your friends who own valuable houses or any assets, let them know this cliff is coming. It would take a huge act from Congress. Congress would have to pass a totally new tax law to replace this. And again, if there's any gridlock in Congress, the Senate, or the presidency, it will not change. So there's a chance, I guess, if Congress got its act together and the Senate and the Congress and the president all cooperated, maybe it'll change before then, but we can't rely on that. What are some rules or levels at which you should be worried about this? Well, if you're single and you have a net worth of around $5 million, that's a big number. I get that. But remember, it includes equity in your home, retirement accounts, life insurance, death benefits, savings, investments, plus future growth. That's all part of your taxable estate. Most people, when they tell us their taxable estate, their estimate, when we actually add things up, their first estimate is usually about 20% lower than what it actually is. Most people undercount that, unless they're keeping close. We have some engineer clients who are really on top of it. They have spreadsheets that are down to the penny, but most of our clients underestimate it. So your estate might be large. You might inherit money in the future. And if your parents don't create a family protection trust for you, anything you inherit in the future is also part of your estate. So it's probably larger than you think. If your estate is around 5 million, your net worth is around 5 million, you're single, you need to be worried about estate taxes. If you're a couple and you're around 10 million, double that number, you definitely need to be worried as well. If you're below those numbers, maybe you don't have to worry about estate tax exposure so much. But if you're younger, hey, we have to look way into the future. But especially as you get older, you need to be aware of these numbers. Well, there are some simple steps everybody can take. You can give away $17,000 per year to as many people as you want, and you don't even have to report it to the IRS. Over time, that can really add up. We have some clients who are grandparents, and sometimes they create trusts for this, but sometimes they just give out gifts to the kids and the grandkids. And if you have a larger estate, $17,000 might not be that much to you, but it might change the lives of the people who receive it. Your nieces, your nephews, your grandkids, your kids. So that's one way you can transfer money without any tax exposure. You can help pay educational or medical expenses for people. That's another quick way to help family out without incurring gift or estate tax, as long as you write the check directly to the school, directly to the hospital. There's some other nuanced rules about that. Talk to your accountant about that to make sure it's done right. But let's talk about the bigger steps that you can take. What can you do to really protect assets from estate tax? Well, we have another talk about that on our Gilfix Law webinar channel. It's called Estate Planning for High Net Worth Families. We give some good examples about that. We have a short video on SLAT, spousal lifetime access trusts. There are a lot of tools available. Michael Gilfix wrote a book, my father wrote a book called Beat Estate Tax Forever. It's available to our clients for free. It's also available on Amazon. It's actually not that long. It's meant to be easy to read, and it goes through some different strategies and tools we can use. But there are ways you can do partial gifting of pieces of real estate to your kids. We can use LLCs, charitable remainder trusts, spousal lifetime access trust. There's a lot of tools out there, but the key is we have to act before it drops. So if you're worried about this, talk to us now. Don't wait till December of 2025. It's about to drop. And it's use it or lose it. The IRS doesn't care how much you have left from the old exemption. If you gave away 7 million or 10, whatever it is, the IRS applies that against the new limit, and any past gifts would go against that limit. So if you don't use all of it or more than what the exemption is dropping to, you lose it. So it's use it or lose it. If you have a larger estate, we need to look at strategies to transfer assets for the benefit of future generations without millions in estate tax exposure. And there's ways, aside from gifting ahead of time, where we can reduce the value of gifts, like discounting. If you give away smaller shares of real estate, like 50% of a house, we can actually get discounts on the value of those gifts. I want to talk about estate planning 2.0. I think we need to go to a new way of thinking about this and doing this. Estate planning 2.0. You don't need to be ultra high net worth. Ultra high net worth families have what we call family offices. That's been the go-to way ultra high net worth families have done things for generations, where they have their own in-house team of estate planners and financial planners and tax planners. And we think you should have your version of that. And we're actually working on building that. We think financial advisors should talk to estate planning attorneys and maybe your accountant as well. When one hand talks to the other, we don't miss things, because we all have blind spots, right? So there's no reason why you should have a financial planner here, or maybe you're using a robo-advisor. They're not going to help you with these high stakes decisions. And you might have your estate planning attorney here. If you have a great financial planner and we work with you, we'd love to connect with your financial advisor. Just make sure we're on the same page, that we understand what's going on, making sure accounts are titled properly. If you don't have a financial planner, if you're unsatisfied with where you are, we are building a program. We are building the Gilfix and the Pole Family Office program, where we're working with some select financial advisors who are going to work very closely with us for clients who sign up for this program. There's no extra cost to clients, and we're really piloting this for a select number of families. But if you're interested in that, talk to us about it. We're building this right now. But regardless of whether you work with us or not, we do think that estate planning should not be siloed and separate from financial planning, separate from your real estate decision. You should build that team of advisors. They should be integrated as best as possible. Maybe it's a formally integrated team, or semi-formally, as we're kind of building, or informal, but you just have joint meetings. But there is no reason why family offices should be only for the richest 1/10 of 1%. If you have any assets you're investing, if you're worried about these issues or protecting assets, why not have the team come together? So let us know if you're interested in our program. We'd love to get in touch with your financial advisor if you work with us to talk about your issues, because it can be as simple as making sure assets are properly titled, that beneficiary designations are up to date. Little mistakes can cause big problems there in coordinating planning. But again, you don't know what you don't know. And so when your team is communicating, we can make sure you don't miss key planning deadlines, like the estate tax exemption dropping, or you don't ignore Prop 19, which might have a bigger impact on your family's future than any investment decision you ever made. 1 or 2 bad decisions or missed opportunities when it comes to estate planning can cost you decades of good decisions from an investment standpoint. And I want to go over a 2023 or 2024 planning checklist, depending on when you're watching this. Do you have a basic estate plan? Do you have an up-to-date living trust? Do you have a power of attorney, an advance directive? If you don't, you need to talk to an attorney right away. We want to make sure it's done properly up front. And if you have a plan, when was the last time you addressed it? When was the last time you looked at it? Do you have the right trust structure? Do you have an AB? Remember, to AB or not to AB? Do you have the right AB trust structure and the non-AB? Depending on your situation, if you're a married couple, that could have huge implications on your family's taxes. Do you have the right successor trustees named? Do you have family protection trusts for your kids? Again, if you have 3 kids, there should be 3 family protection trusts, unless there's special needs planning issues. So every child, we recommend you don't leave your children a penny. Do you have Dynasty Trust? You should leave it to Family Protection Trust, aka Dynasty Trust, instead, to protect from divorce, provide protection against divorce, provide protection against lawsuits, provide protection against future estate taxes. If you have a child with a disability, a grandchild, a niece, a nephew, you need to be aware of special needs trusts and coordinating planning, so assets go to a special needs trust for that child and not to that child directly. If you have a larger estate, if you're single, over $5 million net worth, a couple over $10 million net worth, are you aware of the coming estate tax cliff? Have you taken steps ahead of time to plan for that? Hey, a good problem to have, but a problem nonetheless. Use your annual exemption if you're high net worth. Make those $17,000 gifts to people that you love. No tax problems with that. Do you own California real estate, a home that you've had for a long time? Any rentals or a vacation cabin? Do you want to save that for future generations without massive property tax increases? If your home is worth under 1.2, under 1.3, $1.4 million, and your kids live in it, Prop 19, likely not an issue. Or if your kids are going to sell all your properties after you're gone, hey, maybe not a big issue. But if you want to give your kids the option of holding on to properties, you need to understand Prop 19. You need to plan ahead. And have you integrated your plan? Have you reviewed your insurance plan, your financial plan, and making sure that's all linked with your estate plan? Is your estate planning attorney talking to your financial advisor if you have those? And I think that's one of the big challenges as more and more people use automated systems, whether it's AI or robo-advisors. A lot of people use robo-advisors, the low-cost way of investing, and you save a little bit in management fees, or that some people are using online documents to create their estate plans. It seems simpler and cheaper up front, but there's no one there to flag major issues for you. So make sure one hand is talking to the other. We'd love to be a part of that. And we think estate planning 2.0 should be this integrated family office for all families, hardworking middle-class families and all the way up. And we are, again, working on building some new, really exciting programs around that. I want to make a key point. Our team is not just me. We have Nick Klingenberg, Renee Conrad, Francis LeBoul, our tax guru, Michael Gilfix, of course, the founder of our firm, along with my mother, Myra Gerson Gilfix. But we'd love to get a chance to work with you. And there's no benefit to waiting. You pay one time to update your documents. You might update them in the future. But not having documents or having out-of-date documents can be such a mess for your family. So you might think, oh, my kids won't divorce. Why should I worry about protecting assets in the future? Well, the divorce rate is 40 or 50%. A lot of people, oh, I'll get to this later. I don't want to deal with this now. Well, will you? Are you sure? I hope you got a lot out of this. Share this with someone in your family who needs to see this, or a friend who needs to see this. We'd love to stay connected with you, and we love to spread the word. We want to empower you with this educational information. Go to our website, gilfix.com/newsletter. Join our mailing list if you haven't. Subscribe to our Gilfix Law YouTube channel. We'd love to stay in touch with you. And if you'd like to set a meeting with us, you can, of course, easily do that by contacting us. You can fill in a Google Sheet if you want to give us information about your properties. You can contact us at gilfix.com. So as my mom likes to say, I hope everybody's staying safe, sane, and healthy. And I hope you got a lot out of this. Take care.